देखिए बात वहीं आ जाती है, इतने दिनों से हम ये सोच रहे हैं कि कैसे करें। तो आपके ख्याल में रिटर्निंग ऑफिसर समझ लेगा बात को या आम शहरी समझ लेगा?
मैं अभी आगे आता हूं।
जो खोसा साहब की बात है, मुझे तो बड़ी भारी बात लग रही है। उसमें मुझे कोई आई एम ट्राइंग टू इन माई माइंड ट्राइंग टू disagree with it, and I can't bring myself to disagree with it. He's saying you cannot give these discreditations, full stop. So maybe these are just rhetorical questions. They don't have an answer. I mean, there are many questions you don't have an answer for.
इसका एक
this may be one of them.
इसकी एक interesting बात
But
बताऊं।
however, nonetheless, Parliament has understood 62(1)(f) better than us and has formulated something. Okay, fine, good for you, Parliament. They represent the people of Pakistan. They've understood it, they've done it. Now, unless I can then say Parliament has done something wrong, the only thing Parliament says कि भाई आपके 7 member bench को हमने follow करते हुए ये काम कर दिया है. It is more in tune with the 7 member bench judgment, section 232(2) than Samula is.
That's right, sir. And मैं थोड़ा सा एक background बताऊं. My lord was originally अभी एक्सप्लेन हुआ कि सिर्फ 3 प्रोविजंस थी, ABC था 62 में. When the constitution was being made, certain amendments were proposed by members who belong to religious parties. I'm talking about the original constitution making, at the time of original constitution making. I'll just read out very slowly. I don't have, unfortunately, a copy of it. 2 amendments were proposed and the motions were made and they were negative. They were rejected. And if I may read out, they are quite akin to what was then inserted through revival of Constitution Order 1985 by General.
Where are you reading from? Parliamentary debates?
Parliamentary debates.
Copies दे दीजिएगा मैं.
जी copies दे दूंगा मैं. I'll just slowly read it out. And these were rejected.
What year is this?
This is, my lord, 1973. These are dated 15th of March 1973, sir. So the first amendment which was proposed was he is conversant with the affairs of the country, which is okay. He is conversant with the affairs of the country and is not reputed for his bad character or for contravening the injunctions of Islam. This was rejected by the House. Second, if a Muslim, he is honest, and not an open violator of the dogmas of Islam and possesses the necessary knowledge of his religion. Both were rejected. And while rejecting it, the speaker said, and I would just quickly read out one paragraph from the proponent of one of these amendments and then the response given by the speaker.
Who proposed these?
My lord, these were proposed by Maulana Abdul Haq of Koda Khatak, Maulana Ghulam Ghaus Hazarbi and Maulana Mustafa Al-Azhari. So these were the 3 members who proposed them and the House rejected them. I just read out, these are very telling passages, what he had in mind and then how the speaker responded. And this is exactly what Justice Khosa has observed. जनाबे वाला, मैंने तरमीम पेश की है कि पार्लियामेंट का जो रुकन हो उसका किरदार, उसका इखलाक, उसका तकवा, उसकी दयानतदारी, इसका मामला शनास होना, इस्लाम के बारे में उसकी बुरी शोहरत ना हो, ये खसूसियात भी लगाई जाएं। असल में इस दफ़ा में ज़ेली तौर से बहुत सी चीज़ें लगाई हैं कि अरकान में इनका होना ज़रूरी है। एहलियत होगी तो मैं अर्ज़ करूं कि ये जो है, यानी जो पार्लियामेंट है, पार्लियामेंट जो है वो तमाम मुल्क में बहुत ही अहम इदारा है। इस ऐवान के अरकान हैं, ये आइन बनाने वाले हैं, कानून बनाने वाले और मुल्क के अंदर अदल व इंसाफ कायम करने वाले इदारे के अरकान हैं। इसका जवाब सर, Speaker responded and then obviously it was then later put to vote. He said, आप मुझे इसका जवाब दें कि आपने फतवा दे दिया कि इसकी शोहरत अच्छी है और वो अहल है। दूसरे कई उलमाए कराम ये फतवा देते हैं कि इसकी शोहरत अच्छी नहीं है, इसलिए ये चीज़ इसके मुंतखब करने वाले जो लोग हैं, जो वोटर हैं, उन पर छोड़ी जाती है। अगर वो समझें कि वो अहल है तो वो अहल हो सकता है। And then ultimately it was put to vote and it was rejected. So
maybe it's a guideline for the voter.
Yes.
Maybe why can't it be considered a guideline for the voter? Maybe you want, it's maybe not on your radar, but you should consider these points.
Sort of inspirational standards for future.
D, E, G, and precisely are that. Now, what happened here? Mr. Uzair Bindari argued and he relied on paragraph 33 of Samiullah, where Samiullah Baloch, with respect, erroneously relies on Imtiaz Lali case of 2007 to say that pre-18th Amendment, the Supreme Court had disqualified someone for life under 62(1)(f) erroneously. Paragraph 33 refers to Imtiaz Dali, which is PLD 2007, Supreme Court 369, which was incorrect. In Imtiaz Dali case, he was disqualified on the basis of a provision which was introduced in Representations of the People's Act through Conduct of General Elections Order, which was Chief Executive's Order number 7 of 2002, on the basis that a person who was dismissed from service on the basis of misconduct or moral turpitude, full stop. They applied this provision to hold that if he could not get back into service, he could not get back into the parliament either under 63. So this is what Imtiaz Dali did. Now, what did parliament do to respond? In 2010, Parliament then placed timelines for GHIJ. Now, J deals with removal from service on the basis of misconduct. They said that if he's removed on the basis of misconduct, he could come back in after 3 years. And on moral turpitude, if he's convicted and after serving the term, he can come back after 5 years. So Parliament had this judgment in mind and responded to it. What Parliament did not have in mind was that while they were creating actually a safety valve under 62(1)(f), against any arbitrary decision by a returning officer, where the returning officer would ask someone XYZ, or somebody would come make an allegation against somebody that he is dishonest or he owed me something and he has cheated me, etc. Parliament pegged it with a declaration by court of law. And that declaration, now as I go in greater detail what that declaration would be, this is the safety valve which the Parliament had created, and unfortunately, from Ghafoor Lady to first Aladino Bhaiyo, the original Aladino Bhaiyo, to Samiullah Baloch, this court then actually turned into something which constitution makers never contemplated. Nowhere in 62 or 63 has anything been made perpetual disqualification.
But before we even get to the time frame, what I'm understanding from you is that we haven't yet crossed the first hurdle as to what kind of a declaration this is. Because under the current dispensation or legal framework, no such declaration can come about. Samiullah goes ahead and crafts a declaration, says that in case there is some civil litigation which comes up with something, then we'll, as a consequence and as an effect, connect it and make him dishonest or a mean. So there is no direct mechanism or procedure available in the current legal framework to achieve such a declaration. So having said that, one option could be that the Parliament goes ahead and decides the procedure, or there is a constitutional amendment, whatever might be the case. How could a court of law like us resolve this issue? Because under the current legal framework, such a declaration cannot be given. So what happens if there's a constitutional provision which becomes practically unworkable under the legal system? What do we do with that provision?
My Lord, my respectful submission is, and I attend to my Lord's question, but if I may just first submit, that such declaration, now if we look at the courts of civil jurisdiction and see its declaration is given by a civil court, this sort of becomes a bit inconceivable, because in what situation would that declaration come out? But if this declaration in the form of a conviction is given by a criminal court,